Please be seated. Thank you, Mr. Bossy. Ms. Cale.
Thank you, Commissioner. Now, I had you at CRW.008.042.8653, Mr. Bossy, which is a letter from Mr. Preston to Duncan Ord of the 14th of November 2018, in which sets out the essential elements of the RSG framework for. Now, at 8669, at about point 4, that heading, Australian New Zealand Gaming Machine National Standard 2016, do you have that?
Yes.
Mr. Preston there sets out how under the standards the machines used at the Perth Casino impose further restrictions than relative to the standards required in other states. There's a reference to the banknote acceptor there, what the maximum amount of money that will be accepted into the EGM. And the point being made here in Crown Perth's RSG favour is that the amount is $100 at Crown Perth is the maximum amount, and it's much higher in other states. You see that?
Yes.
Tell me, how does that note acceptor limit operate in respect of cashless EGM gaming, such as the ticket in, ticket out technology?
The ticket in, ticket out allows what's on the credit meter to be put to the ticket. So if the credit meter has potentially in excess of $100, it would be transferred to the ticket.
So there is no limit on ticket in, ticket out gaming?
Don't know. There's no limit, but it's certainly it could be above $100. Yes.
You don't know?
Oh, if there's once a machine gets a certain amount, you will lock up the machine. And it depends on how the win occurs, right? So if there's a jackpot win that goes on there, which is a large credit meter amount, a machine will lock up and will do a hand pay, as distinct from applying the tickets, but it is above $100.
Now, at the bottom of the page, there's a reference to the return to player, and the point being that that's 90% in WA, whereas in other states it's lower, somewhere between, I think, 85 and 87.5%.
Sounds right. I assume
We
it's
look
on the
over the
next
page,
but that's
yes.
right. That
Let's have a
sounds
look.
about right.
I'm sorry, just before we leave that page, can I, that, the reference to, in that bottom table, that reference to South Australia, note acceptors prohibited.
Yes.
Does that mean you can only use chips?
Historically, it was coins only. I think since 2018, I do understand that South Australia has introduced note acceptors, but prior to that, it was coins only.
Coins.
I believe. Coins and notes. You get both.
Thank you.
Coins and chips.
Sorry, coins. Just coins. Sorry, in South Australia, it's only coins. Dollar coins. It'll be. I assume it's dollar coins.
But it might be notes now, is your point.
I believe it's changed, and notes are now allowed.
Now, if we go back up to the top of the next page, where return to player is considered, and there you've got other RTP percentages ranging between 85 and 87.5%, with WA on 90%.
Yes.
And you understood that these features were being included in here because they are RSG features. They are the higher return to player, the banknote acceptor limit, and then the speed of play, which is mentioned here. Do you see? Being 5 seconds rather than the lower maximum amounts in the other states are all features that mitigate harm caused by gaming machines.
They can mitigate harm. Yes.
Yeah. Now, you're aware of the amendments in 2019 to the WA appendix to the Gaming Machine National Standards,
Yes.
and you accept that these amendments were instigated by Crown,
Yes.
and GWC was approached to approve those amendments after internal discussions within Crown in which you were involved,
Yes.
and the letter submitting that the changes should be made from Crown to Perth is at CRW.709.132.6302, a letter from Mr Felsted to Duncan Ord of the 7th of March 2019. So that's just a few months after this letter setting out the RSG framework. And if we go to the last paragraph on page 6302, which is at the front here, see the rationale for asking for some of the factors in the appendix to be changed because of the commercial disadvantage that Crown Perth has against interstate and international operators. Would you agree that that was the rationale and the motivation for Crown seeking a change to the appendix to the national standard?
That was part of the rationale. Yes.
What was the other part?
In considering the options that were put up in this letter, a number of factors were taken into account. If you've got a moment, I can go through those. We considered it on behalf of multiple stakeholders. The way the games were designed, I touched on just prior to the break. We had, in WA, the game design made the game much more volatile than you normally get. One of the statistical analysis we did was we looked at our more popular 32 games, I think it was, and after between 30 and 45 minutes of play, they would average a return to player on a modal distribution of something akin to 80%, which is lower than other jurisdictions. So the volatility of game design that came out of the appendix and out of the requirements of Western Australia made the game more volatile. And we were getting customer feedback related to that. I met with customers, I spoke to them. So then to mitigate that volatility and experience, which again, not enough research has been done whether that is a mitigating factor with respect you believe it is, but that's my opinion. You then look at alternate ways to do that, so that you can get to game design. Unfortunately, none of the manufacturers wanted to get involved in game design. We actually went to one of the major manufacturers in the country and wanted to pay for modified game designs. They wouldn't even allow us to get a game design that was less volatile for our customers. So the way to mitigate that is you can look at lowering average bet, and you can do that multiple ways. One of which is when we ask for speed of game will allow you to reduce the denomination of the game, which ultimately leads to a smaller bet for the customer. So statistically, if I go back to 2017, about just over 40% of our games were at a 5-cent denomination, and we had about less than 10% that were in 1 and 2 cent denomination. As a result of game speed, which enabled us to reduce the denomination of the game, we are now running about 35% of our games at 1 and 2 cent capability. So we've brought the average bet down materially as an option for the customer. So what we've recommended here, we looked at it and said that will help with harm minimisation. The other part, from a financial perspective, we were in a tough economy. So my focus was, how do we save jobs? Save jobs, as you mentioned earlier, the machine business is a big business for us. So how can we save jobs? We've got to look at continue to try and grow our business. So there was an element of that to the decision-making process. To the extent we would succeed in that space, and there was no guarantee, we would then end up paying more tax to the government. We would save jobs and shareholders as well. So you've got multiple stakeholders we considered in putting this paper to the government as a recommendation. It wasn't as simple as what was put in the letter.
So your point is to say that there were other reasons for seeking these changes which are unexpressed in the submission.
There's multiple reasons why.
So just listen to the question, please. Is your evidence that there were other reasons for seeking the changes to the appendix that are not expressed in the letter of submission?
I don't know. This is a substantial letter. I don't know how much more was expressed in that letter. And what I see here, it's not in that element of it is not in this.
Did you review this letter last night?
Yes, it's not in. Can you scroll down the page a little bit? So cost of EGM development is absolutely a reason for that. Our manufacturers weren't making the game, and they were charging us a lot more money for the games that they did make. Customer choice was in there within those games. So there are multiple factors that led to this process. That is a part. We'd have to have a look at the entire document to see further elements of it.
Being shown it now.
Delays in access to new product was absolutely an issue for us. An example would be phone call lightning links,
Well,
5 years old.
Isn't the rub here on page 6304, after the second dot point, the first full paragraph, when collectively assessed, these three factors materially disadvantage Crown Perth, and to address this unfavourable and uncompetitive environment, etc.
These three factors do materially disadvantage, and there's more. There's lots of factors in this sense, and how we get there to a decision.
Well, what was motivating Crown Perth quite plainly was its commercial disadvantage in the casino marketplace, wasn't it?
There was a commercial disadvantage, and it reads that way, yes.
And just to answer my question, you agree that it was the material and primary motivation for seeking the change to the appendix?
It'll be a material change, yes.
Was the primary reason why Crown Perth sought to change the appendix, wasn't it?
Yes.
And can I just take you back to something a moment ago? Were you suggesting that the maximum bet on a gaming machine and the speed of play have a fixed interrelationship?
No.
So you can have a slower maximum speed of play and have a higher bet, can't you? A higher maximum bet.
You can have a lot
You
of
can set
options.
it.
Yes.
You can set
Yes.
it wherever you want.
Yes.
Yeah. So if you decrease the maximum speed of play
Yes.
from 5 seconds to 3 seconds, but you make no changes to you don't lower the maximum bet, people are just going to spend more per hour, aren't they, on the machine?
It's not. It's the minimum bet is
Sorry, I
what
beg your
you
pardon,
want
the
to
minimum bet.
change. If that was the case, that would be correct, but that's not the strategy we took. We took to lower the minimum bet materially as a result of these games.
From what to what?
You went from a 5 cent game, which on a typical pattern, a 40 pattern game, is a $2 bet if they play all patterns, to a 1 to 2 cent game, which is an 80-cent minimum. So you've dropped it by the scale of the denomination.
And who was commercially ahead? Crown or the patron?
In that scenario,
Lowering the maximum speed and decreasing the minimum bet.
that's a very difficult question to answer because it depends on how the patron behaved and the patron segmentation. Theoretically, let's start with a theoretical model, the patron is ahead. Because you've dropped the speed from 5 to 3, but your average bet has dropped from 5 to, say, 2. So your multiplier on the average bet coming down is greater than the speed. But it depends on the customer and the behaviours and what they choose to do.
Right.
If applied in that formula.
But in practice, what happened after it dropped from 5 second to 3 second, just listen to the question, is that Crown Perth's revenue from EGMs went up significantly.
Yes, it did. The growth in revenue was related to the fact that the change was made pre-COVID versus post-COVID. So what happened in that time period was a very different customer demographic that visited. What, just in general terms, in what you saw in the marketplace, if you looked at, and I looked at this statistic not long ago, if you looked at states like New South Wales, Queensland, South Australia, and I believe Tasmania as well, they all grew between 10 and 20% on pre-COVID levels. We were at a similar level. So economically, we've moved at a similar level. What we had pre-COVID versus post-COVID is we had a younger demographic, we had a stronger economy, we had customers with more to spend because they weren't able to travel. There was a number of factors that changed the demographic and the performance of the business well beyond the game itself. If the game was materially better for us, we should have grown substantially more than the other markets because they didn't have apparently this change.
Are you
Would be
saying
my
that
argument.
the increase in EGM revenue after this change was not in any way due to the reduction in speed from 5 to 3 seconds?
I'm not saying it's not. I'm saying there's a lot of determining factors that has changed the market.
Was it one factor which added to Crown's revenue from EGMs?
I believe it was because we got a lot of new games that otherwise we wouldn't have had as well.
No,
So it was a factor.
I'm not talking about adding new games. I'm talking about reducing speed.
Yes, it was a factor.
It was a factor.
Thank
Thank you.
If we come back to page 6303, and if we just put that, yes, thank you. There's 3 amendments that are proposed. One is the reduction in the speed of play. Have you got that there on the screen, Mr. Bossy?
Yes, I do.
From 5 seconds to 3 seconds.
Yes.
It doesn't say anything about the minimum bet, does it?
No.
No. And then the return to player, you wanted that reduced from 90% to 87.5%. Yes?
Yes.
And then you wanted changes to the design characteristics so that the symbols to generate an outcome didn't need to be independently generated, that they could come off a virtual fixed reel strip. Is that right?
Yes.
And all of this was designed, wasn't it, to bring the features of EGMs in Western Australia at the casino closer to the features of machines used in the eastern states
Yes.
to save on the costs of game development.
To save on the costs, yes, and also to provide more new games for the customers who were asking for more choice.
so that they could gain more.
Just choice. It may well gain more.
And if we go over the page, here in the table, if we just blow that up, please, are the amendments that are being proposed to be made to the appendix. Do you see that?
Yes.
There's nothing on that page that talks about changing the minimum bet amount, is there?
I don't know if minimum bet's part of the appendix, but no,
Right.
there wasn't.
Okay, let's go over the page. And if we blow up the table there, nothing about the minimum bet amount there?
No.
So when you were giving evidence a moment ago about how the minimum bet amount was tied to this change, were you saying that it was part of the submission, that you promised to do that, or what?
No, it wasn't part of the submission. It was how the strategy evolved within the business.
Well, why wasn't it part of the submission if the desire was not just to financially advantage Crown Perth, but was to, in fact, as I understood part of your evidence to be, also to advantage the patron?
The minimum denomination at 1 and 2 cent was always an availability in the design. So if we could put it in there, but it's already in the base of the design of a game.
In any event, you accept that reducing the speed of play, reducing the return to player, and removing the requirement for the generation of symbols to be independently generated for the outcome, these were all RSG features that you were diluting by these proposals.
We were diluting, put them in combination, and the outcome is not as clear cut, but yes, we were diluting those factors.
And you must have concluded that changing these design features in the appendix could increase the risk of harm to patrons using machines with the new features?
That was the consideration, that was the description I had at the beginning, which was denomination with the speed allows the customer to play at a much lower level than they do today, than they did at the time.
But you didn't embed that in the proposal, did you?
No, it doesn't look that way.
And did Crown Perth, before it put forward this submission, do any research to consider the RSG implications of what it was proposing?
I don't believe we did research.
So if we go to, did it do any analysis of the RSG implications of what it was proposing?
We did analysis on an expectation of where we thought, what we anticipated the average bet would move down to. To that extent, the average bet is a combination of denomination, gain speed and patterns. So we did an assessment on where that could move to. But in terms of direct relationship to RSG, I just thinking about it, I'm not exactly sure how we do that, but I'm happy to contemplate it.
But did you do it as a part of considering whether or not to put this submission forward? Did Crown Perth do an assessment of the RSG implications of this proposal?
Not that I'm aware of doing an analysis of the RSG implications. The expectation of average bet coming down was something you would consider in RSG, but no, I don't think we did an analysis on it.
Right, if we go to page 6308, please, under the heading Responsible Service of Gaming, refers in the first paragraph to that overview of the framework that I took you to before, that was delivered to the GWC in December 2018. And then do you see in the second paragraph says, while Crown Perth has a sound and robust RSG framework, highly committed to ensuring all game products and services are offered in a responsible way. It says we are of the respectful view that the proposed amendments to the appendix will not have any impact on gambling-related harm. There's no basis for that assertion, was there?
No, not research-based, no.
Well, not any based, was there?
No, other than a viewpoint, but no.
Well, if it were a viewpoint, it was a view based on nothing.
No statistical evidence, no.
Well, can you give any explanation to the Commission about why Crown Perth would have said that to the GWC in those circumstances?
No.
Pardon?
No, can't.
Would you agree that in relation to its EGM business, Crown Perth places greater importance upon maintaining or increasing revenue than on minimising the risk of harm to patrons from playing those machines?
Revenue is a consideration, but this was a proposal that had a framework that could have led to a lower level of harm, but we do have a focus on revenue. We certainly have that.
I'm asking you this question generally, Mr. Bossy, in terms of the business, the EGM business generally. Would you agree that Crown Perth places greater importance upon maintaining or increasing revenue than on minimising the risk of harm to patrons from playing those machines?
We do have a harm framework, but yes, we have had a higher focus on revenue growth. However, we've spent more money in the last period on harm minimisation and processes within that. We're working at resource increases as well. So I think we're at a point in time, but we're evolving.
Well, I think you told me before lunch that the amount you're spending now is still not enough.
Yes, but it has doubled since the letter in 2018.
Do you agree that Crown Perth's approach to advertising to Perth Casino members and Crown Perth's loyalty program likely increases the risk of harm being caused to patrons playing EGMs?
Can you repeat the question?
Do you agree that Crown Perth's approach to advertising to Perth Casino members and Crown Perth's loyalty program likely increases the risk of harm being caused to patrons playing EGMs?
Yes, there's a likelihood, yes.
And do you agree that the changes made to the gaming machine national standard in 2019, as instigated by Crown, also likely increase the risk of harm being caused to patrons playing EGMs that conform to that standard?
Again, I'm going to go back to where I was. The way the product has been rolled out and the way the multiple variables that came into play, the betting patterns have a chance of lowering. In fact, the framework is set to do that. Has it got a chance? Change always has the chance.
Would you agree that instead of an RSG framework that is primarily focused on empowering patrons to make their own choices about their behaviour, it would be more appropriate for Crown Perth to focus its RSG framework on its own conduct by not making machines available to patrons that are likely to cause them harm?
Can you ask that question again, please?
Would you agree that instead of an RSG framework that is primarily focused on empowering patrons to make their own choices about their gambling behaviour, it would be more appropriate for Crown Perth to focus its RSG framework on its own conduct by not making machines available to patrons that are likely to cause them harm?
There's multiple parts to that question. Firstly, we have to identify what kind of machines cause which kinds of patrons harm. We can spend even more time in that space, but when we looked at volatility, we tried to get a national volatility. We tried to get a volatility index across our manufacturers, not dissimilar to what you'd have if you go to a movie and they give you gradings on what that movie is, or you got alcohol and they give you percentages, we were looking to have a volatility index across manufacturers, and we couldn't get it up. That would have been helpful for the customer because they all use different matrices in how they calculate it. So from our perspective, I think there's an element of what we can assist with, but I think there's also a broader requirement for the industry to try and get some standards up on that as well.
Well, Crown Perth can simply do its research into the addictive characteristics of different games and simply not have the most addictive types at its casino. Would you agree?
We can do that. We don't understand that until the game arrives and we get enough data to do that assessment. When a game first arrives, we don't know whether it's within the addictive set or not, if that's how we describe games. Only once you've got a certain amount of play behaviour on a game can we assess the volatility of it, how it gets played and what customers are doing. But the manufacturers themselves don't give us a real indication of that.
Well, they might if you refuse to buy a machine until they did. Would you agree?
We could. We'd have to agree what those conditions are so that they can measure it against to suit the market.
Ms. Cale, just while we've got that document on the screen, I'm sorry to interrupt, but could we go back to page, I think it's 0604, that document? And could you pull out that passage in the middle, when collectively assessed? I just want to understand your evidence, Mr. Bossy. You, at the start of that exchange, you said, well, there may be other factors that are not expressed in this letter.
Yes.
And it's a complex thing. And I think, correct me if I'm wrong, but I think you've agreed that the pointing out of material disadvantage was a significant factor in this letter, and that those three factors, speed of play, RTP and independence of outcomes, were certainly part of the pitch, if I can put it that way. But as I understand, am I correct in understanding your evidence that these other factors, the context, impacts on, or at least it's expressed in the impact of material disadvantage, and that's things like the retention of employment, the increasing in customer experience, those things. Is that what you were getting at?
That's where the material disadvantage for Crown certainly sits. It's these three factors. If you put them together in the way a game is presented to a customer, have a material shift in what that experience is. Speed of play allows you to reduce the price point of entry. The way games get made, there's a lot more analytical work, statistical work that's done on machines that are sold globally than this market. Manufacturers don't even supply to this market because of our uniqueness of our machines. So there's multiple factors that go to setting the experience for the customer. So the material disadvantages we were talking about was at the time, it was an economy that was not performing well. So there was a financial attribute to that. We'd gone through a series of redundancies with staff and job cuts, and potentially more to come. So yeah, there was multiple factors that we considered.
Right, thank you.
Mr. Bossy, do you accept that Crown Perth could do more than it presently does to bring a proper RSG focus to its promotional and advertising of electronic gaming machines?
Yes.
And you're aware, aren't you, that Crown Perth is presently moving towards cashless gaming at Perth Casino?
Yes.
Would you agree that this obviously presents as a potential further risk of harm to patrons because of the ease with which money will be made available to them for gaming?
Possibly. There are other factors. We do have we are running an FPOS trial on tables, and there are limitations on transactions. You have better trackability of transactions. So if we could have a scenario where there's some combination of data sharing and analytics that go beyond Crown specifically and involve banks and combine that, you could have actually an improved, I think, RG framework because of the amount of data that's involved.
Mr. Bossy, there are clearly RSG risks associated with cashless gaming, aren't there?
Yes, there are.
And one of them is the ease with which money is made available for gaming.
Yes.
And another one is that the patron may have a lack of appreciation as to how much money they are actually spending if they're simply waving a card in front of a reader. Would you agree?
Yes, that's not how it operates at Crown, but we insert a card, you have to have pin pad control. The transaction is limited in terms of lower than the bank limits on your card. We implemented that proactively. The regulator approved a larger limit, we reduced it. So there are elements of control you can put on cashless, more so than cash.
Would you agree in the context of moving to a cashless system, it becomes all the more important for Crown Perth to look at its own conduct in terms of the sorts of machines it makes available and how it promotes them to Perth casino patrons?
I think that's an element of it in terms of how we promote. The framework you approve on cashless capability and technology, which has evolved dramatically, is important as well.
Can I take you to the problem gambling services committee that you are now a member of? You've recently joined that in your capacity as CEO of Crown Perth, is that right?
Yes.
And at paragraph 159 of your witness statement, which is at page 0105, you make a comment about the funding model for that committee, and you say that there appeared to be an immediate need to increase the financial contribution from Perth Casino, and you raised it by 25%.
Yes.
And as I understand your evidence going on from this, you saw that immediate need without having any insight into what the committee did or what its funding requirements were. Is that right?
Yes.
So you could just look at it objectively and say, well, the amount we're spending is not enough.
Yes, on the basis of you're looking at a state position that's providing services and is providing advertising and awareness to the consumer, and to provide that to the state is at 60% of the level of what we were spending internally.
Right.
So that needs a shift, but in that committee, I'd like to see a plan and a structure and a framework going forward to determine how much that committee, what the funding of that committee. But it was at $1.2 million for the year. We alone were spending $2 million, and that's an entire state.
However, Mr. Bossy, you were always aware historically of the contributions Crown Perth made to that committee, didn't you? Because you were sitting on the RGM committee.
I don't know if we discussed the financing model, but I was aware, but I can't recall it ever being highlighted in the committee in discussions.
Well, do you mean that you were aware of the amounts, but you had never turned your mind to the adequacy of the amounts contributed?
Yes, that's a better way of putting it.
Why not?
I don't know. No excuse. I never turned my mind to it.
Right, now I want to change topics and come back to junkets, Mr. Bossy.
Okay.
And if we can come back to the ICB and specifically junket tours to Perth Casino. You saw or heard about the Four Corners program in 2014, didn't you?
Yes.
And you'd been at Perth Casino about 3 years by then?
Yes.
And you understood that program raised serious questions about the legality and propriety of junket operations to casinos like the Perth Casino.
Yes.
Now, you've made clear in your witness statement that it was not part of your responsibilities to approve junket operators or junket participants who came to Perth Casino, is that right?
Yes, that was a centralised function.
And it wasn't your responsibility to conduct any due diligence upon them?
Due diligence was conducted centrally, primarily.
It wasn't your responsibility.
No.
But you were responsible for the integrity of gaming at Perth Casino, weren't you?
In delivery of the service, yes.
Yeah. And I suggest you would at least have wanted to seek reassurance from others whose direct responsibility it was to vet the junket tour operators and participants, that they had been cleared through their processes as appropriate people to be gaming at Perth Casino.
Yes.
And did you do that on each and every occasion a junket tour came to Perth Casino?
Not on each and every occasion, but we certainly asked questions about certain customers that would arrive.
Why didn't you do it on each and every occasion?
I can't recall certain times there was large volumes, which made it a challenge to get to everybody.
What was the trigger or reason for you to make an inquiry?
To the extent there was a requirement, it often came through in the. It would have come through the checks, some of the checks that we ran, a world check or a customer that was raised as a potential person of interest.
So you were aware that potential persons of interest were coming to Perth Casino to game,
Yes.
and that raised a concern in your mind?
On occasion, yes.
And what was the concern that it raised?
Whether they should be visiting.
But what was the risk that you saw associated with their visit?
Something in their profile. Could have been an associate or something along those lines.
Do you mean an association to criminal conduct or criminal activity?
It was, in one occasion it appeared to be, yes.
And the risk of money laundering occurring through the operation of the tour or gaming by a particular participant?
I couldn't tell that from what I observed.
I'm asking about what your concerns were that made you make an inquiry.
Typically it was related to persons of interest, whether it was news articles or their associates.
Yes, but was it criminal record, criminal association? What was it that you were concerned about?
Association.
Criminal associations.
Potential, yes.
And what did you do about it when you thought somebody had a criminal association that had been approved by the ICB business to come to Perth Casino?
I raised it with either the international team or the legal team.
And what would happen then?
On one occasion, the individual did not turn up to Perth.
And on other occasions?
There's one specific case that I'm thinking of. I can't recall what happened in the other occasions.
Were there occasions when you had concerns, you raised them, the concerns were not alleviated, but a tour operator or participant nevertheless attended Perth Casino?
I don't recall. The one occasion is the one that I do recall, but I don't recall.
Where that person didn't come?
Didn't come, yes.
When junket tours came to Perth Casino, the ICB team hosted them, as you've already mentioned, yes. And the junket tour participants were often transported using private jets belonging to the Crown Group, to your knowledge?
On occasion, yes.
Well, was that a typical way that they were transported?
I wouldn't have said typical.
Was the local, when the junket tour arrived, whether it was by a Crown private plane or elsewhere, was it the local ICB team responsible for the logistics of getting the junket tour participants off the plane, unloading their luggage and transporting them to the Crown Resort Complex? Yes. Did you ever physically oversee that process?
What with
go and
what
meet
respect?
The tour?
No, I did not meet the tour. I tried not to engage directly with the tour because part of my function was if something went wrong, I'd be the person who would confront and have potentially adverse discussions with those groups. So to greet them would set the wrong, in my mind, would set the wrong tone if I was asked to do that.
What's the sort of things that you had in mind that might go wrong, to use your words?
To my perspective, we had an example of a customer that wasn't behaving appropriately. He was a large customer. Staff weren't comfortable, so I came in.
You mean physically harassing staff?
No, not physically harassing, was just very vocal and just trying to intimidate. So I came in, would have been 12:15 in the morning, met with the customer. He specifically addressed me somewhat aggressively. And I said to him, if you don't calm down, not only will I remove you from the property, I'll escort you to the airport. He went back to his room. He ordered his plane and he flew out 6 hours later. He was meant to be there for an additional 3 days.
Now, apart from that incident that you've just told me about, is there anything that you have yourself witnessed or have heard about that someone else at Crown Perth has witnessed about the process of meeting the plane or transporting the passengers and their accompanying baggage that has caused you any concerns about the legality or appropriateness of the activities or conduct of tour operators or participants?
I can't recall. I can't recall.
So does that mean you don't remember any
Well,
instance?
if the customer would arrive, our team would go and greet them. They'd get them to a car. Car would drive them to the hotel. They'd then be taken to the hotel room, and that was the typical process.
And you never heard anyone raise concerns about anything that had occurred during that process?
Any particular concerns you're referencing?
Well, I just put it to you. The legality or propriety of the activities or conduct of tour operators or participants.
I don't recall, but I don't recall.
Now, typically once arrived, these participants in a junket tour spent large amounts of time gambling continuously in one of the VIP rooms, didn't they?
Sometimes the participants did. As a junket group, they would have, but they would move around the place, but they could have spent extended periods, yes.
But it wasn't unusual for junket participants to gamble through the day and night?
I wouldn't say it was. I wouldn't say that was the usual practice at all.
So what was the
They would
usual
break
practice?
down. They play late at night. Yes, they might play golf during the day. They typically the more popular time to play was between 6 p.m. and 4 a.m. I'd say is probably the most popular time. They typically were later gamblers.
In those other activities such as golf and so forth, the junket tour participants were hosted by the ICB team, were they?
They were involved in the process, yes.
Yeah. And were you involved in overseeing the ICB team hosting those other activities?
There'd typically be a senior manager who had access to give me a call if any issues raised, but that would typically come by Melbourne direction to that group.
Were you involved in organising the dealers for the table games for junket tours?
The gaming team did that. Yeah. Gaming team reporting to me did that.
So you were
operational team.
So you had to give final approval to the dealers who were dealing the table games for junket tours?
I didn't deal with the roster and who the actual people were involved. We've got rostering teams we have certain staff that are trained to deal and have access to the areas they deal with. It's not every dealer that can deal in the salons, and our operational teams would manage that process.
So you didn't have involvement in selecting the dealers?
No,
Did you check in on the gaming activity in the VIP salons
periodically, yes.
at different times of day and night?
Periodically, yes.
Did you ever see anything when you did check in that indicated to you possible money laundering occurring in the room?
Not in the salons, no.
Or anywhere else?
No.
Did you see players using mobile phones in a way that suggested the possibility of gambling at the direction of someone who was not present at the casino?
I don't recall ever seeing that.
Did you see or hear about any conduct by junket tour operators or participants during their gaming at Perth Casino that caused you any concern as to the legality or propriety of the conduct?
Can you ask the question again, please?
Did you see yourself or hear from anyone else at Crown Perth about any conduct by junket tour operators or their participants whilst gaming at the Perth Casino that caused you any concern as to the legality or propriety of that conduct?
I don't recall that. I don't recall that.
You gave an example, a detailed example, or an instance that you remember
Yep.
a moment ago about a player, a participant behaving inappropriately towards the staff in a salon. Was that a frequent problem?
No, I wouldn't call it a frequent problem. Customers, VIP customers on a regular basis asked dealers to be changed. That was not uncommon. They had a sense of change of luck. They selected preferred dealers of who they'd like to deal cards to them. They may have periodically spoken and engaged with dealers a little aggressively, but our operational team would be dealing with that on a day-to-day basis. And if it was of interest, such as this particular customer, it got escalated to me.
Now, you mentioned golf a moment ago as a, if I can put it this way, an extracurricular activity,
Yes.
an activity different from gambling.
Yes.
What were all of the activities, to your knowledge, that were engaged in by junket tours?
We had a boat, the Infinity, that people toured on. They went on helicopter flights down to Margaret River. They went to Rottnest Island. They went indoor skydiving. They went shopping quite commonly. Created events, fireworks events for them, concerts, lots of different variations of events.
Performances, you mean?
Concert performances, yes. Yep.
Yeah. Anything else? Bars they went to. They went out to Northbridge and what have And any other activity?
you. Not that I'm aware of.
Were you aware of any activities offered or in fact organised by Perth Casino that caused you any concern as to the legality or appropriateness of the activity?
They went to some bars in Northbridge that I'm not sure what the bars were, but it was karaoke bars. I'm not exactly sure what occurred in those locations.
You had concerns about what occurred in those locations.
I had a couple of conversations with my team
And what were those concerns?
about those, clarifying what was occurring at the bars.
What was
And they
occurring
were-
at the bars, you
They
were
would,
told?
they would have drinks and they'd have entertainment and girls and would be there, but anything more than that I'm not aware of.
No one's told you anything about what went on at those bars that's caused you any concerns?
Not that I'm aware of those bars that I was told.
Now, when a junket tour ended,
Yep.
The ICB team was responsible, was it, for putting the participants back on the plane at the end of the tour? Transporting
Yes,
their baggage
yes.
and them?
Yes.
And did you physically oversee that process at any time?
Very, very few occasions. Very few occasions.
Is there anything you've witnessed yourself or heard about from anyone else at Crown Perth about the process of putting the passengers, the participants back on the plane, transporting their luggage to the plane and so forth, that's caused you any concerns about the legality or propriety of the activities or conduct of junket tour operators or their participants?
Not that I recall. Junkets typically left in the same manner they arrived. Not that I can recall anything.
Have you ever been made aware of Crown Group private planes being used to transport junket participants to places other than Perth or their home jurisdiction?
From Perth or anywhere?
Well,
Yes, they would be transported to Sydney and other locations if they chose to.
and places outside of Australia.
Possibly, yes.
Now, I want to take you to the minutes of the ERCC of 19 May 2015. That's CRL.639.001.0334_R. Page 0344. And this heading AML CTF update, do you see that there?
Yes.
Now, you were an apology for this ERCC meeting, but you would have read the minutes afterwards, presumably. And you see there's a reference to Crown Perth's decision to allow junket operators to be in a company name.
Yes.
You recall that decision?
No, I don't recall the decision, but it's in the minutes, so I accept it.
You agree that allowing junket operators to operate in a company name would increase the risk of money laundering occurring through the Perth casino operations?
It may well, yes.
You are aware, aren't you, of the steps taken by Burswood Management in 2017 to have residual regulatory requirements for names and passport numbers of junket participants provided to GWC?
Yes.
To have them removed? Remember that?
To have that removed, there was a communication. What date did you say?
2017.
Sounds about right.
Yeah. What did you understand to be the rationale for the request for the removal of that requirement?
Have you got a copy of that letter there?
To Mr. Connolly
Yes.
from Mr. Preston, CRW.513.005.3696. I think it's not for publication, so we will just put it on your screen. Do you recall that? There's Mr.
Yes, I do.
Do you want to have a look at this letter, which might remind you better? It's also not for publication, CRW.513.005.3701. It's a letter from Mr Hume to Mr Connolly of the 16th of March 2017. The removal of the procedure to provide the names and passport numbers of junket participants to GWC. You recall that?
I think that was sent to me yesterday, yes.
Now, what did you understand to be the reason behind requesting that relaxation?
I would have to speculate as to the why. This would reduce the visibility on the customer arriving.
Well, to the GWC it would, wouldn't it? So what was the rationale for Crown Perth pressing for the relaxation?
I don't think there was a requirement at the time to minimise the visibility on a customer.
Could you just give me that answer again, please?
Potentially minimise the visibility of the customer.
I think that was the motivation to ask for the relaxation.
Well, I don't know if it was the motivation. I didn't write the letter. I don't believe I was involved in the preparation of the letter, so it's a bit of a speculative position that I take on this.
Were you aware of, in 2017, Austrac's casino junkets investigation?
No.
And the concerns, you weren't aware of Austrac's concern that casinos in Australia were not sufficiently focused on the identity of junket participants?
Don't recall the Austrac report.
Now, do you remember writing to Mr Connolly in August 2018 seeking approval from GWC to have a junket operator, Mr C, set up a business desk and facilities similar to hotel business centre facilities at Perth Casino?
I do recall.
And this document is not for publication. It's gwc.0002.0016.0241. You remember writing this letter?
I recall this letter.
And why did you write this letter? In the sense of how did this fit within your area of responsibility?
I signed the letter because I was of the senior people in town. I was the one on the ground. This is a junket operator who was proposing to have frequent visitors to Crown.
Had you done any due diligence investigations into Mr C as to his background before writing this letter?
Not sufficient.
Not sufficient?
No.
Why not?
I've got no excuse. I should have done more.
Did you consider before writing this letter whether permitting an operator to establish business centre facilities at the casino might increase the risk of the Perth casino operations being used to facilitate money laundering?
In writing this letter, I relied on the work done by the due diligence team in Melbourne and the work that they would typically do in this area of our business. They had the skill set and the teams to do this.
You're aware that Simon Pan was a junket participant that was banned from Crown Melbourne on 16 August 2019?
Yes.
And yet he was permitted to enter Perth Casino 29 times after that?
Yes.
and there was no system in place until very recently to share information between the Perth and Melbourne casinos about persons who had been banned.
There was, we've made a number of changes, yes.
Well, it was an issue that the ERCC, of which you were part, were well aware of.
Which element of that?
That there was no system in place until very recently to
There
share.
wasn't a cross-property system of barring in place. There was a couple of, there was a number of reasons that was discussed within particularly the relevant security teams on both sides of the country. One of the restrictive measures that occurred was that the information in Victoria wasn't able to be shared with Western Australia based on their requirements, their regulatory requirements. Whilst that changed in 2018, WA we could share information equally, but Victoria wasn't in a position to share with us on barred persons. In 2018 that changed, however, as of today, we're still not in a position to share police commissioner barring lists across the borders. So there were a couple of mitigating factors that limited the creation of a shared barring policy. So recently we implemented some changes to try to align as much as we can, but we still have a little gap there. We've got an MOU with WAPOL, and I think Victoria's working on something similar.
Can I just understand the evidence you've just given? There's a barring order at,
yes.
for example, Crown Melbourne, or it
yes.
could be Crown Perth, is presumably based on, often based on evidence about a person's criminal record or criminal associations or similar.
Not necessarily. A barring order could be issued because a customer was in a fight, or a barring order. There's lots of reasons a customer would have barring. So to automatically bar across the country, it depends on the nature of the barring.
All right, but let's say you've got somebody who ought to be barred across the country.
Yes.
For reasons that can't be disclosed because the information comes from WAPOL or similar.
Yes.
I'm not quite sure I understand, what's stopping Crown Melbourne picking up the phone or sending an email that says Mr. John Smith ought to be barred from Crown Perth? Full stop.
Putting aside the police commissioner list, let's park that one. There's nothing stopping it in the sense of, should it occur, which it does today, a barring policy across the organisation wasn't equal, and there wasn't a requirement necessarily to do that at the time.
And
The
why
security, I'm not exactly sure why not, other than the security departments manage the barring process in both sides of the country. They use the respective systems to bar players. Upon understanding what happened with Mr. Pan earlier this year, we implemented a process where we were barring people across the country. It's a weekly update list that is supplied from Melbourne to Perth and Perth to Melbourne. So we're updating the list today. Previously, there was a decision taken not to have a mutual barring across the country, and that sat within the legal and compliance team.
And when was that?
When
When was that decision taken to not have a mutual barring?
Well, there was never a mutual barring order in place previously, so I can't say that it was a proactive decision or it was just a reactive decision. I can't tell that because that's what's existed.
But you accept that
for years.
ERCC, at least from 2017, was aware of this issue about people being barred in Crown Melbourne, not being Crown Perth not being notified.
No, I get that, but in 2017, it wasn't able to be shared, the information based on the restrictive requirements in Victoria. That didn't get approved till 2018.
So I'm just trying to understand what was preventing, before 2018, Crown Melbourne ringing the relevant person up at Crown Perth and saying, Mr. Smith should be barred from Crown Perth.
I can't remember the reference point, but I think it was, it don't want to quote a position in the event it's wrong, but the head of compliance contacted me earlier this year, and in 2018 they got approval to share barring lists with Western Australia. Prior to that, there was a regulatory form of restriction. I don't know whether it was in the Casino Control Act or another form, but there was a restriction in sharing barred player information, as I understand it.
I'll change topics now and turn to AML, anti-money laundering, and Riverbank. Now, at page 0101 of your witness statement, paragraph 135, you accept that you were one of the signatories, authorised signatories to the Riverbank account opened with the Commonwealth Bank of Australia in 2014.
Yes. What was the location? Oh, here it is. Thank you.
It should just be there in
Yeah,
front of you.
it's just come.
Yeah. Was it usual for you to be made a signatory to Perth Casino Bank accounts?
I don't know how usual it was. This occurred quite rapidly and with a less than adequate form of communication.
So it was something unusual.
Yes, me being a signatory, the process of me becoming a signatory on account is unusual.
Right. So did you pay attention to what you were being asked to be a signatory of, which account and why?
The account, yes, it was fairly vague, the description as to why.
Well, who asked you to be an authorised signatory to this account?
I think the communication came through our Treasury team, if I recall correctly, but I can't remember exactly.
Treasury team in Perth or Treasury team in Melbourne?
Melbourne.
And who within the Treasury team?
I can't recall. I think the can't recall. I think. Oh, I don't want to even say I think, because if I get it wrong, this was an account that was opened up and I was placed to be a signatory on.
Now, what were you told about the whys and wherefores of you becoming a signatory when you were asked to do that?
At the time, it was just opening up a bank account for international players. I was not a, as much as I was a signatory, I was not a primary signatory, and I was not ever asked thereafter that I can recall to ever do anything with the account, to even understand the account. It was in the event of we don't get any other signatories, we're going to have you on the list. So it wasn't, I wasn't ever advised any further than when I signed on that I can recall.
Now, so your evidence is that you, as far as you are aware and as far as you remember, did not authorise or affect any transactions on any Riverbank bank account? Not
that I'm aware of at all.
Now, I think the next document is not for publication. Before I go there, when you became a signatory to the Commonwealth Bank Riverbank account, did you know that ANZ had recently decided to close the Riverbank account that was held with it?
It may have been discussed. There was a lot of discussion at the time on different elements of the VIP market, so
it may have been discussed.
May have had that piece of communication come to me.
Well, you signed the signatory authorisation form in March 2014, and then a few months later in June, if you go to not for publication document CRW.529.011.173. Just have a look at this document.
Yep.
We need to zoom out, please. We can see in the second half of the page the 23 June 2014 email from Mr. Do you say that?
Tyler,
Tyler?
Mr. Tyler, yes.
Tyler. You're CC'd
He was the head of
into
Treasury.
this. Travis has set up new Riverbank accounts with CBA. I understand this was communicated to the sales team some time ago.
Yes.
And then if we go to page 1739, there's reference there to the closure of the Riverbank accounts at ANZ. Just if we drop down, please. Drop down. Do you see at the bottom half of the page from a Mr. Jeffrey Lee? Please kindly take note of the email below in regards to
Yes, I see that, yes.
Riverbank investment. So you were
Yes.
aware at least a few months
Okay.
after you became a signatory on the CBA account that the earlier ANZ bank account for Riverbank had been closed.
Is that what Carolyn's email
Shall we go over the
says?
page?
Yes, it is, okay, yes.
So you were aware within short...
Now I am, yes.
Well, you were aware at the
Yeah,
time, is
I
what I'm
received
asking
the emails,
you?
yes, I received the emails, yes.
And do you remember being aware of the closure of the ANZ bank account at around the time you became an authorised signatory of the CBA account?
Yes, it was the ANZ account, so I would have been aware of it. Whether I would have tied the two together despite having the same name, but yes, by the
Well,
look of this.
did it cause
yes.
you any concern that ANZ had closed Riverbank accounts in 2014?
I recall some discussion about moving banks to continue transactions, yes.
With whom?
Roland and the team noted earlier.
Which team?
Team above, the international team.
And what did they tell you?
That this is a transactional account that we will run with international.
What about the reasons for the closure of the ANZ account?
I don't recall the reasons. In fact, I'm not even sure they explained to me the reasons for the closure.
Well, did you ask?
I can't recall.
Did you ever wonder why the bank account had been named Riverbank rather than something that was more obviously associated with the Perth casino?
I didn't particularly think about it, no.
Did it occur to you that the Riverbank account might be an attempt to hide, the name of Riverbank might be an attempt to hide its association with the operations of Perth Casino?
Didn't occur to me at the time.
Now, in 2019, you were notified that the CBA Riverbank account was closed, or was closing. Do you recall that?
In 2019, I recall that it was closed, yes.
You recall being told about that?
Oh, there was. The email was brought to my attention. I don't recall being told, but there was an email that was sent my way.
You're referring to an email which is not for publication, crl.605.016.6602, dated 4 October 2019. And here at the top is, well, at the bottom actually, from Mr. Costin
Yes.
to you and others who've been informed about the closure of the Commonwealth bank account, both South Bank and Riverbank.
Yes.
Now, did you make any inquiries at that time about why the CBA bank account had been closed?
It was 5 years after the original transaction. I actually didn't recall even being a signatory on the account.
Did you make any inquiries about why the CBA account had been closed?
Not at that time, no. As I said, I forgot. I didn't realise I was a signatory at that time. I've only recently been made aware of that.
Well, you're at least sufficiently involved to be included in this email, weren't you?
Yes.
So the bank account had now been closed by two banks, the Riverbank, and you're still not alive to any concerns about the reason, to find out the reason why.
This was a number of years had passed, and I wasn't involved in the banking work that was going on. I should have, in hindsight, wonderful thing, I should have inquired further than I did.
Now, did you see on the live stream Ms. Fuster give evidence before this commission?
No, I did not.
Are you aware that she gave some evidence about a conversation she had with you earlier this year in February about Riverbank?
I didn't see the evidence. What did she say?
Well, first of all, before we go to what she
Yeah.
said, do you recall having a conversation with her about Riverbank in February this year?
I had a number of conversations with her. I recall one in March. In terms of February, possibly.
About Riverbank?
Not specific. Riverbank was, I did discuss with her Riverbank in March that I can recall. February, I don't know. We had a number of discussions about a lot of different things.
Do you recall a discussion about Riverbank?
In March, yes.
And what was the discussion?
She asked me about Riverbank at the time. I said that I had a look, I had visibility of the transactions as a result of the detailed letter sent to Mr. Duncan Ord on December 14. That was a report from Grant Thornton and Initialism that laid out transactional data from the accounts, which was the first time I'd seen the transactional data in those accounts. And I was surprised about that, the transactions in there and the report.
Can we just have a look at Ms. Fuster's transcript of evidence at page 1575 of the transcript, line 45. So down the bottom of this page at line 45, Mr. Futrell SC says, I would like you, he says to Ms. Fuster, I'd like you to be specific as you can about that conversation and what you said to him. This is to Mr. Bossy, you. Mm-hmm. When the conversation took place and precisely what words you said in response.
Okay.
And then her evidence starts over the page. And she says a range of things between lines 5 to 40. And then if we get down to line 41, on page 1576, so over on the right-hand side, Mr. Bossy, are you with me?
Oh,
Yep.
okay, down there.
Yeah.
Yeah.
And Mr. Futrell says, again, I just want to be as clear as you can be about what Mr. Bossy said to you about his knowledge of the Riverbank account. She says, I remember him having a shock on his face going, I didn't know about the Riverbank account either. I'll let you read on. So
Yep.
I didn't feel I got resistance from Mr. Bossy on it, or he was trying
Yep.
to talk. He seemed to have been and we'll just go over the page, surprised as I was.
Yeah, okay.
Now, is that an accurate reflection of your memory of your conversation with her?
February TWR, I don't recall the conversation. The conversation, I think there's something about context here. At that time, I was already aware of the transactions. So the conversation I would have had with her may well have been shocked. I may well have said I didn't know about the Riverbank account either, in the sense of, as I said earlier, it's been quite a period of time, but the context I would have had that with was the context of the transactions. And understanding the detail of the account is where the biggest surprise for me was.
Right, now let me ask you about the CUP process. This is a new topic, Mr. Bossy. Can we go to your evidence at paragraphs 130 to 134 of your witness statement, pages 0100 to 0101? Now this concerns the CUP process, the China Union Pay process that had been implemented in Melbourne. You know
Yes.
what I'm talking about?
Yes, I do.
Process by which international players could draw credit from a Crown hotel using a China Union Pay credit card to draw funds to gamble at Crown Melbourne.
Yes.
Now, at paragraph 132 of your witness statement, you give evidence to the effect that in around 2012, when it was first raised with you, you discussed it with Mr. Preston, and you and he both agreed that it should be resisted as a proposal to be introduced at Crown Perth.
Correct.
Was that resistance because you thought that there was a risk of that process being used to facilitate money laundering?
It's not, I don't know I don't think money laundering's the decision here. It was once I understood at the time that the capacity of withdrawal was up to $500,000 using that facility. It's the scale of that withdrawal that sparked some concern with me, and it did not appear, from my perspective, it was not something that I was comfortable with, having a credit card functionality that can be that large, and hence I do recall being quite vocal in my resistance within the organisation thereafter.
So you didn't want that procedure or the facility to use that procedure introduced at Crown Perth?
No.
Now, if we go to CRW.709.103.0500, this is an email from Neil de Lima to you on 8 May 2013. And Neil de Lima was a chap in the ICB business in Melbourne,
yes.
wasn't he?
No, he was in Perth.
In Perth, all
Yes.
right. And so he was part of that ICB hosting team, was he,
Yes,
in Perth?
he was the leader.
Okay. Now, he's asking you, where are you at with the CUP process
Yes.
and using it at the, this is at Crown Perth.
Yes.
It didn't happen immediately, did it?
What?
It wasn't rolled out at Perth immediately?
No, it wasn't. Neil de Lima asked me then. I got a number of requests from the international team, and my response to them was, we're not going to do it here. I contacted the team in the hotel and advised them that if it does come here, I want them to call me before it lands.
All right, so, but the reason it wasn't rolled out in Perth in 2013 was because in Melbourne they said, well, look, stop, we're putting some refinements to the process.
I'm not aware why that occurred. What I can answer is my position on it consistently through the period. Now, I don't know what the Melbourne position was on this at the time.
You're aware that Mr. Preston wrote to Mr. Connolly in April 2016 about this process?
I have been made aware of that.
Are you saying you weren't aware at the time?
At the time, not aware.
At all?
I don't believe so.
He didn't discuss with you the amendments to the casino manual to allow the CUP process to be rolled out in Perth?
I don't recall the conversation.
So completely ignorant of GWC being approached to amend the casino manual in 2016 to allow the CUP process to be deployed in Perth.
The structure of the operation was Mr. Felsted led the international business. The hotel business structure was reporting in to the Melbourne team through Mr. Kress. And Mr. Preston was with the was reporting in through Mr. Falstead, so there was an opportunity that could get implemented without my visibility on it.
Right, so just to be clear, I think this document might not be for publication. CRW.701.004.3544, letter from Mr. Preston to Mr. Connolly. That's not for publication. You looked at this document last night, did you?
I believe so, yes.
If we just cursor flip through the pages so Mr. Bossy can see. That's it. You had no knowledge of that letter or its attachments at the time that it was prepared and sent to GWC?
I don't believe so.
And nor were you aware that those amendments to the casino manual were then approved by GWC in May 2016?
That I'm aware of.
Now, can I take you to this document that's not for publication, CWN.514.006.9412? Here we are after the approval in May. In September 2016, Mr. De Lima here in Perth emails to you asking about the availability of the CUP facility at Perth from October.
At that point, I would have spoken specifically to Neil and probably Mr. O'Connor about not having the facility here. I didn't change my mind on the facility.
But you must have, getting this email, thought, well, how did that happen without a GWC approval? Did you go back and look at the, look to see how that happened and find out about the letter Mr. Preston sent to Mr. Connolly?
I don't recall seeing the letter from Mr. Preston to Mr. Connolly.
See, this email is expressed as if it's your responsibility and
I understand
approval required to actually practically implement this process. Do you see that?
But it didn't get implemented.
But you must have been aware of the building blocks that had been put in place to implement it. Would you agree?
I should have been, yes.
Or were you?
Not that I recall. I took this as the usual Neil type of email, which was indicating something would occur, but not necessarily having the approval process.
So did you go and see Mr. Preston and say, well, look, this isn't going to happen?
Can't recall whether I did or didn't, but I may not have.
Isn't it the case that the actual reason why this CUP process was not rolled out at Crown Perth was because shortly after this, the China arrests issue erupted, and it meant that there were no junket tour participants or junket tours coming from China?
That may well be the case.
And then if we go to this document, which is not for publication, CRW.709.098.6940, which is an email chain of July 2018. And at 6941, just because it's in reverse order as usual, Mr. Bossy. And to basically summarise, if you're happy for me to do this, you and Mr. Preston are being given the explanation by Mr. Hume that he and Mr. Murray have met with what I assume are some ICB people. Is that right? Jacinta Maguire,
Yes,
Ishan
they're all
Ratnam
ICB
and
people.
Indra Davies.
Yep.
And they're wanting the CUP process to be recommenced or commenced. You see that?
Yes.
And Mr Preston says at the top to Mr Hume, happy to progress with the use of this facility, however, and then he emphasises we will not be using CUP.
Yes.
And then if we go over the page and to 6940 and we drop down, you say to him, calm down, etc. You've delivered the same message to Mr Murray, Paul and Michelle. So you didn't want it rolled out either?
No.
And what was the reason as at 2018 for that?
Same reason as 2012. It was, CUP was not something I was interested in having at the property.
But you did you know by now about the 2016 amendments to the casino manual?
At this point, yes.
And you must have therefore been aware of the contents of the letter to Mr Connolly?
No, it was a discussion with Mr Preston.
So if we go to this letter, crw.706.006.0039, which is a letter of the 6th of July of this year.
Can we just go back for a minute before we get to this?
Where do you want to
Just
go?
the previous comment that I made.
Do you need to look at do you need to look at a document to make the comment?
No. My awareness was not that, again, I didn't think about it in terms of the Connolly letter. It was a conversation about not having CUP anymore. My previous comment was not about being aware of the changes that the Mr Connolly letter made. It was about not having CUP.
Right, but you were aware of the contents of the 2016 letter to Mr Connolly?
Not at that, no. I still didn't ask for the contents of the letter. It was a discussion around CUP that we were having.
Now, you remember this letter from the Chief Casino Officer last month asking you to confirm that CUP practices did not occur at Crown Perth?
Yes.
Yeah. And then you responded on the 26th of July, so that's just a couple of weeks ago.
Yes.
CRW.701.004.3552. So this is your response, and if we go to page 3553, over the page at numbered paragraph 7, you say Crown has, in relation to amendments to the casino manual in 2016, Crown's identified documents which suggest that the purpose for requesting the 2016 amendments was in fact to implement the hotel transactions practice at Crown Perth.
Yes.
See that?
Yeah.
So you've done a bit of investigation now into this.
Now I have. That's
what are the
identified
the documents there that you have identified?
That letter to Mr Connolly that you referred to previously that outlined the changes was the primary.
What else? Because it's in the
changes to
plural.
the casino.
What else?
That was the primary one I looked at, I've got to say. And I looked at there was the letter of a submission, and I believe there was a letter of approval as well that came with it from the.
Now, if we look at numbered paragraph 8, Crown's not yet addressed this matter with any current or former Crown personnel who were involved in the submission of the request. But you say you certainly were not involved in the submission of the request.
No,
Right?
I don't believe so.
Yeah. You go on to say it's a matter of concern to Crown that there may have been a lack of candour and transparency in its dealings with the GWC in making the request. See that?
Yes.
And are you making inquiries about that now?
We're in the process of, but in the last week I've been preparing for this, so I haven't had time to pursue the follow-up.
Now, but you're clear that you are not one of the people who exhibited a lack of candour or transparency, potentially in dealings with the GWC in relation to that matter.
I don't recall that matter.
Now, your position is this, isn't it, that there were never any such CUP transactions pursuant to the procedure by way of the amendment to the casino manual.
Yes, I believe that to be the case.
What investigations have you undertaken in that regard to substantiate that conclusion?
I've spoken to the cage team and the hotel team. The standard process for CUP was to have the transaction commenced at the hotel and then consummated at the cage, neither of which said that there were any transactions in that space. I asked the departmental heads and they investigated and gave me that answer. So I have some faith that they will tell me the right answers, but that's who I've asked.
Right, different topic here, Mr.
Could we just, before we move on, so that I understand it, can we actually go back to the email, Mr. Preston's email, and then your response to it, which is July 2018, sorry?
Yes, CRW.709.098.6940. Is that the one, Commissioner?
Yes, so first of all, Mr. Preston's, which is the page before, as I understand it. So, just reading that, Mr. Bossy, Mr. Preston says, happy to progress with the use of this facility, however, we will not be using China Union Pay. So when you read that, do you understand is that what Mr. Preston is saying is that he's happy to have overseas patrons use credit card facilities at Burswood Hotel, at the Burswood Hotel or hotels, to obtain funds on credit, which they then use for gambling on the casino floor. But as long as they're not, the organisation providing the credit isn't China Union Pay.
Reading that now, that's how I'd interpret it.
But then we go to your response.
Yes. Mine was a particular reference to China. Yeah, my response was a particular reference to China Union Pay was the message.
Well, you say this is the same message I delivered.
I understand that,
There
but
are two parts of Mr. Preston's message.
Agreed, and that's why I said reading it now, I'd see the two parts of the message. My message to the team was no China Union Pay. So I've poorly worded the email.
And indeed, when you then look at Mr. Preston's response to you, he says, I think they will be looking to use other cards, not CUP. I'm just not quite sure how the tenor of this exchange is consistent with what your evidence is that you didn't want the process to occur at all.
China Union Pay specifically was the card and the process that I was particularly focused on. At the time in 2018, there were discussions around restrictions or other transactions relating to movement of money in and out of China, and this looked to be a vehicle to facilitate that. I was specifically concerned with CUP in terms of how that looks.
Well, not just how it looks, but,
no, but
if other
process.
If other credit providers are being used, the effect is the same, isn't it? It's just not China Union.
I don't know if it was the same. It was just China Union Pay was the particular card I was focused on.
And that's because of the very high monetary limit, is that what you said?
It was the high monetary limit and the fact that it was related to Chinese transactions with money, both of them.
Make an NFP just in case.
Specifically.
But no matter who the credit provider is, it would still, if Chinese patrons were allowed to do it, or any patron, it would disguise the fact that they were using that money for gaming?
Reading it, yes, it could.
Well, that was
Yes.
the purpose of it, was it not?
Yes, looks that way, yes.
Thank you, Ms. Cater.
Ms. Cale, I am a bit concerned about the time.
Yes, certainly I am too. I've got 3 more questions. Mr. Bossy, have you ever extended or approved the extension of credit to a domestic player to gamble at the Perth Casino?
Domestic being Perth or state, interstate?
Either.
Have I approved credit? I don't recall doing that. International, yes.
Have you ever allowed or approved permission for a patron to exceed the limits, a domestic patron to exceed the limits of a cheque cashing facility whilst gambling at the Perth Casino?
Yes.
Which is in effect granting them credit, you'd agree?
My understanding of cheque cashing facility was that it was, when I was given advice, was not deemed, wasn't discussed as credit from my perspective. When I first arrived here and cheque cashing facilities were advised to me, it was an appropriate form of accessing cash at the time.
Whose cash?
Theirs, customer would give us a cheque and we'd allow them to.
Up to a limit?
Up to a limit, yes.
Have
an
you ever
agreed
allowed
limit.
them to exceed the limit whilst they're gaming in the casino?
On their request, yes.
So you've granted them credit?
I didn't think about it in those terms. Given a cheque cashing facility is an approved form of transaction.
Nothing further, Commissioner?
Mr. Bossy, we will finish your evidence today, but I think it's appropriate that we take a short break to give you a rest. So we'll take 10 minutes.
All rise.
please.
Please be seated. Thank you, Mr. Bossy. Mr. Bossy, as Commissioner Jenkins said earlier this morning, counsel for other parties now have an opportunity to ask.
Can I just return to a response that I just made on cheque cashing facilities? Can I correct a
You
comment?
certainly can.
A process is a customer requests an extension of credit on site through I think it's line 14 of our cheque cashing facility documentation. That then comes to me. I approve that request for an extension from the customer, and then the customer goes to the cage to get a CPV, which they then take to the table. So the customer signs 2 to 3 documents and also asks or requests for the extension in the first instance. So it's to that extent I approve a request for an extension first.
But what are they approving? Money, the delivery of money from their bank account, or the extension of credit from Perth Casino?
No, well, a cheque is a document that is a commitment, and we hold the cheque in similar to cash.
But when it's exceeded, where does the money come from for the immediate availability of those funds to the patron?
Tied to the cheque that the customer signs, which will be the account.
So they then sign a fresh cheque.
Typically, it'll be that and a CPV request.
What's the CPV stand for?
It's a chip purchase voucher that allows them chips to play.
But they've signed a cheque for the amount.
Yes,
that
they have.
So there's no additional amount beyond the cheque value.
No, there is an amount that they can only go to the limit of the amount that's been approved.
So I might just get a real life example. So somebody's got a $50,000 cheque cashing facility limit with Perth Casino, and they're in the middle of gambling at a table, and they reach their $50,000 limit. They've lost $50,000 and they have no more chips left to play with.
Yes.
And they want an increase in the facility limit while they're playing, because they want
The
to immediately
same facility,
continue.
yes.
So what happens?
They will request more. They'll sign a document to get that. Sign a document that outlines what they were, the amount they're looking to extend to, and then I'll approve. I will approve that extension.
And where does the money come from to buy them more chips to the value of the extension?
Either the cheque they sign, is what typically occurs, or that the casino will provide them the money.
But if the casino provides them with the money, that's an extension of credit, isn't it?
Within that program, could be deemed that, yes.
Well, it is, isn't it? I beg your pardon?
Yes.
Thank you.
All right, does anyone seek leave to cross-examine?
Commissioner, thank you.
Mr. Power?
Yes, I've been allocated the first bay, so I'll take it if you don't mind. Mr. Bossy, I want to clarify some aspects of what you say.
Could you just remind
I'm
Mr.
sorry,
Bossy
yes,
who you represent?
I did introduce myself to Mr. Bossy earlier. I'm from Morena Fuster.
Yes.
Thank you. Mr. Bossy, I want to clarify something which you say in paragraphs 57 and 70 of your witness statement. I'll bring up paragraph 57 on the screen now so you can see that. Now, we know from paragraph paragraph 8 of your statement that you were appointed to the position of Chief Executive Officer of Crown Perth on the 9th of December 2020. And following that, there were 2 board meetings, one on the 16th of April 2021 and then the 17th of June 2021. That's correct, isn't it?
That sounds correct, yes.
And you had not held the position of Chief Executive Officer prior to your appointment on the 9th of December 2020 in any organisation, had you?
No.
And the last 6 months of your role as Chief Executive Officer you have described as a transition. Did you find it challenging?
No, this last 6 months has been extremely challenging.
And as part of the reason for that, the number of senior executives and other key personnel who have resigned.
Yes.
And as a result of those resignations, a loss of support for you in your role.
There was a material amount of support lost, yes, they were key roles.
Now, would you accept that in the last 6 months since your appointment as the Chief Executive Officer, you have been doing some learning on the job?
Required to do the learning as a result of the lack of some elements of support, but
Yes.
also as a result of some of the new people that have arrived and the skills they've supplied has also been helpful.
All right. Now, in paragraph 57, you refer to some regular contact with Ms. Fuster. Do you recall an occasion when Ms. Fuster spoke to you about the need to get board packs out to the Burswood Limited board about a week before the meetings of that board?
I do recall those conversations.
And do you recall initially resisting that, but then going back to her after speaking to a Ms. Bronwyn Weir and agreeing that the board packs needed to go out at least a week before the board meeting so that the board would have time to digest the contents?
I don't know if I'd term it resisting because of at the time that I'm not sure the specific date you're talking about, but that is a period of time where we lost Ken Barton resigned. John Poynton had stood down as chair of the board. We'd had a series of inquiries called in particular. So my discussion with Ms. Fuster would have been, we will try our best to get them out early. If that's deemed resistance, then that's resistance. The intention was to get them out earlier than we could. But because the source of the board papers was a number of staff members or a number of people both here and in Melbourne, because of the skill set we're talking about in the agenda items, that was the challenge we had with an inquiry on foot in Melbourne as well.
All right. Well, whether you call it resistance or not, is it the case that you went to Ms. Bronwyn Weir, spoke to her, and then went back to Ms. Fuster and agreed that they should go out a week before?
Ms. Bronwyn Weir was a very new recruit, and I hadn't met her before, and she was recruited to be the secretary of the organisation. So I needed to have a conversation with her. So I agreed. I certainly returned to Ms. Fuster and said, we'll agree, and we're working our best to get them out earlier.
All right. Was one of the other matters about which Ms. Fuster spoke to you the need to have a matters arising section in the board pack so that ongoing matters could be tracked as they progressed?
That was one of the comments.
And with those two pieces of advice that Ms. Fuster gave you, would you regard them as helpful in you doing your job as the CEO, not having done that role before?
Yes, Ms. Fuster was helpful in that sense.
And are they the sorts of improvements to the board packs that you speak about in paragraph 70 of your witness statement?
Can I go to paragraph 70, please?
Yes. Bring up paragraph 70, please.
Yes, Ms. Fuster's feedback, particularly at the April meeting, was very valuable in assisting an improvement for the June meeting, and we will continue to develop that.
Now, in the other discussions that you had with Ms. Fewster, did she from time to time call you to get confirmation from you about information that she had read in media publications and ASX announcements concerning the Crown Group and what was happening in the Crown Group?
She did call me, as I would call her as well, about the updates. I wasn't aware she wasn't on the ASX releases at the time as well. I don't believe she may have missed a few of them. We've certainly got her on, and where possible, I've tried to discuss with her in advance. So,
You recall her pressing you between February and April of 2021 for a board meeting?
yes, we both agreed we had to get that board meeting happening as quick as we could.
And do you recall her pressing you in around the same period for some meetings with Allens, the solicitors, so that she could get an update on what was happening with this Royal Commission?
Yes.
And are these examples of the sort of information that a non-executive director might expect to receive, in your opinion, to do her job properly?
At the time, the volume of information passing through the organisation across multiple fronts, from whether it was inquiry related, whether it was remediation related, whether it was various aspects of what we were confronting, it was changing dramatically. And yes, absolutely, it would have been helpful for her in her function.
And it's the sort of information which might be received by such a director in the course of a board meeting if and when they occurred, isn't it?
It would be. I was working to try and keep her updated as much as possible. To the extent I may have fallen short, I fell short, but I did give I tried to call her on a regular basis to try and keep her informed.
The Commission pleases.
Thank you, Mr. Power. Any other applications?
Could I just clarify one matter in relation to the questions Ms Cahill put in relation to electronic gaming machines?
Yes, Mr. Evans, thank you.
Thank you. Mr Bossy, I act for the Gaming and Wagering Commission. Could I just ask you a couple of questions so that the Commission can be in no doubt as to what the evidence is in relation to the application which Ms Cahill took you to change the rules in relation to electronic gaming machines, which was made in March 2019?
Yes,
You recall those questions?
some of those questions. Is there...
That application was approved in part in the middle of 2019, was it not?
Some, I believe it was in July.
Yes. For the Commission's reference, the relevant board meeting is a meeting of the Gaming and Wagering Commission held on the 23rd of July 2019. The document is GWC.00002.0016.0285, page 2 at item 5.3. That led to an amendment to the appendix, the Western Australian appendix to the gaming standards, did it not?
Have a look.
You may be familiar that in order to effect
Yes.
this change, a change to the gaming
Yes.
standard was actually
Yeah.
required.
Yes.
For some reason, Commissioners, I haven't been able to find that on the database. There is a September 2019 amendment to the appendix. If it doesn't exist, we'll arrange for a copy to be tendered separately.
Thank you, Mr. Evans.
The effect of the amendments which were approved were these, weren't they, Mr Bossy? First, the reduction in the return to player was not supported. You're nodding, perhaps you could
Correct.
say
Correct. Yeah.
So the return to player remained at 90%.
Yes.
The standard gameplay time remains 5 seconds as a minimum. A game without any enhancements.
Without
free
any
games.
enhancements. Yes.
That's right.
Without any of the features. Yes.
And a reduction to 3 seconds was supported only if there are additional features in the game.
What do you mean by additional features?
That is, there's a free game or there's something else, the effect of which is to extend the effective play time beyond 3 seconds.
Yes, that's my understanding.
And the reason there's an extension of the effective game time is because those additional features require additional player interaction in order to initiate them.
I don't know if that's the specific reason, but the features do start and they play, and it takes a lot of additional time when the customer gets that element of the game.
And there are two elements of certification which you provide to the Gaming and Wagering Commission, are they not? The Crown Casino certifies on a periodic basis the return to player
Yes,
across each game and across all of the games.
over each 6 months. Yes.
And the type of report which you provide, I haven't found the latest one, but they're provided to the Commission and appear in the Commission's agenda packs. And for the year ended 31 December 2018, the relevant agenda pack is GWC.0002.0016.0268. And can I take you to pinpoint 90, page 90 in that agenda pack? Page 90. Now this is signed by you, Mr. Bossy. You recognise either this letter or this type of letter?
Yes.
No, it should indicate that there's indications of confidentiality in the information which follows. So perhaps we could make this desktop only. I don't know whether my friend Mr. Darman-Handel wants to make a not for publication request, but so you use a third-party certifying organisation to run game time analysis. Is that correct?
Yes.
And if we can page down to the next page. One can see on that page, can one not, the analysis of the games actually recorded against each machine, the turnover of that machine, the revenue derived, and the return to player as a percentage.
Yes.
And if one runs down to the end, there is a sum figure which appears on page 93. Across the totality of all of the games for the relevant period. And can I just take you on, you talked to Ms. Cahill about the question of volatility, and that's what, so the Commission's going to understand what that is. Can we take you to page 98? That might be blown, the chart perhaps be blown up. You obviously have a very good grasp of the statistics in relation to this, Mr. Bossy.
Got some grasp.
As I understand what that chart demonstrates is it illustrates the return to player depending upon the number of games played. That is, as a matter of statistics, or probability and statistics, the more times you play, the closer to the mean you should arrive. When you responded to some questions from Ms. Cahill about individual player volatility, you were talking in terms of the number of games an individual player would play in a relatively short period.
Correct.
What this chart shows is the number of games that could be played overall, in fact 10 million games against a particular machine, and a convergence around the target payout rate of 90%.
Yes.
As a result.
Yes.
So if you play very few games, it could vary between 85 and 95%. But the more games you play, the more you converge upon the target. Is that correct?
Yes.
Now, I understand that there's a second certification, and I'm not sure whether it's been provided yet. I've only seen reference to it. But you retained external testing laboratories to actually validate the play time. You recall that?
The
speed of play?
I did, yes.
And you wrote to the Commission in relation to that on the 7th of December 2020 for the approval of a testing methodology.
Yes.
The reference is in the Commission's Commission's board pack, GWC.0002.0016.0336 at pinpoint 116. And I won't take you through that, Mr. Bossy, but that's a letter which explains the methodology to be adopted and the two testing laboratories, one of which is the testing laboratory, I understand, which is used by Crown Casino, that is BMM Test Labs,
Yes.
and one which is retained by Gaming and Wagering Commission as its independent tester, which is Gaming Laboratories Australia.
Yes.
Has that validation actually been undertaken at this stage?
We can I answer the what we call the jet stream chart that you showed,
Yes.
that you showed with up to 8 million spins. There are games out there that do not normalise until 121 million spins. Right, so 8 million, it sounds like a lot, but some games don't stabilise until that level. The higher the volatility of the game, the longer it takes to normalise. So just to get to that jet stream, like I said, 8 million looks like a lot, but it is quite surprising how long it takes to normalise. In terms of this process, I'm not sure we've received a response on whether this is an approved process, but we have asked our manufacturers to start to produce the games not with a 3-second minimum, but a 3.5 second minimum, so that we would, in the event that it might get close to not hitting the mark, then we cover that. What we did also find out in this process when we did talk to both accredited testing facilities is their underlying methodology was different. One used, I think it was BMM used an autoplay methodology, whereas GLI used what they called a more human behaviour methodology. So based on what each of them did, the same game could be approved at, say, 5.2 seconds under BMM, but under GLI it'd be 6.5 seconds. So they're applying different testing methodology, which actually until we went through this process, no one even understood. So as we're going through this process, we're trying to put a framework together that allows a regular testing regime, both pre and post installation of the game. That's the background.
But at this stage, you don't know, you haven't at this stage validated that the games are compliant with the 2019 approved standards?
I'm not sure. I can't answer that question. I'm not sure whether.
If you can't assist the Commission, Mr. Bossy, no need to answer further. Thank you. Thank you, Commissioners. I've got no further questions.
Thank you, Mr Evans.
Yes, Commissioners, I seek leave to ask
Seaward.
questions on 2 topics. Thank you, Mr. Bossy. I act for the Department of Local Government, Sport, Cultural Industries. If I could take you to paragraph 157 in your statement. Just while that comes up, this portion of your statement deals with your recent involvement in the Problem Gambling Support Services Committee.
Yes.
And I understand that you have recently joined the committee.
Yes, I have.
And so you've only attended 2 meetings this year, is that correct?
Correct.
And prior to attending the first meeting, which was on 27 May this year, were you aware of the different programs that were funded through the committee?
Aware of them, but until I got into the committee, I probably didn't understand them as well as I should have understood them.
And so going into that first meeting, was it still at the stage where you were still learning exactly what programs had been funded and the processes the committee followed?
I wanted to understand what the committee was endeavouring to achieve, because I'd never been part of the committee before, and we had a number of conversations on what is that role, what is the plan, and tried to see where each of the respective members were. I hadn't met anybody I hadn't met most of the people in the room, not everybody, but most of the people in the room.
And you comment in your witness statement that the committee hadn't met for a period of time, almost 2 years beforehand.
It
Did you
surprised me when I found out, yes.
Yes. And during the course of the first meeting, was part of that reason revealed to be COVID-related reasons?
That is, there was, I don't recall the reasons for it, but it would be fair to assume that COVID would have disrupted whatever the meeting schedule was.
And did you understand that even though the committee had not met for that period of time, the funding of the programs had nonetheless continued over that 2-year period of time?
Oh, yes. Yes,
So the
I was aware of
programs
that.
were still occurring?
They were still occurring, yes, but
Yes.
the committee hadn't
The
met,
committee
and I
hadn't.
wasn't sure what the committee, when I got there, was
Yes.
planning to do.
And part of the consideration at that first meeting was the previous strategic plan for the committee?
Yes, that was provided.
Yes. And that strategic plan was 2017 to 2020 originally, but had been extended by a Rotary resolution in the previous year to go to June 2021 until
Understand
the
that to be
committee.
the case.
Yes. And so one of the tasks of the committee is now to consider a new strategic plan for going forward.
Yes.
By the time you went to the second meeting, in your statement you say that greater detail was provided to you about the various programs.
Yes.
And in that meeting, which was on the 1st of July, is that correct?
Sounds about right.
Yes. So recently.
Yeah.
And so the different programs that have been funded were discussed, and there were some annual reports for those various programs provided.
Yes. Good statistical analysis as well, and a few other bits and pieces. Yes.
So we've got the Problem Gambling Helpline,
Yes.
which is the telephone counselling service provided by Medibank,
Yes.
and the Gambling Help Online, which was the national online counselling
Yes.
service, correct?
Yes.
And then there's the Gambling Help WA, the face-to-face counselling done here by Centrecare.
Yes.
And then during the course of that meeting, there was a discussion about a number of tasks the committee is going to work on going forward.
Yes.
And one of those is the development of a terms of reference.
Yes.
And that's something you state in your statement you were keen to see.
Yes. I
So the
think
committee was-
myself and Lotteries West were as well.
And the second meeting also talked about looking at a new communication and advertising plan for the problem gambling awareness campaign.
Yes, well, awareness is critical in achieving, I think, what we're trying to achieve here.
Thank you for that. If I could get you to look at paragraph 217 of your statement. Now, in this paragraph, if you go about midway down the paragraph, it commences with, "I'm aware the department on at least one occasion has held an event at Crown." Now, you state there that the transactions being undertaken by the relevant convention sales team. By an event held at Crown, are we talking about an event where the department has hired out through the standard sales team one of the rooms at the centre to hold an event?
That's what I've been recently advised. We have held commission meetings at Crown on occasion, but that I didn't deem that to be the same.
No, and so were you given any information about what that event was?
No, I wasn't.
Okay, you're not suggesting in there that it's anything other than the department acting as another entity who can come and hire the centre for a
Oh,
commercial
absolutely.
value?
That was the point of the exercise, was convention sales teams at arm's length, and it was an appropriate transaction that we would expect them to have as a hiring entity.
Thank you very much. No further questions.
Thank you. Are there any other applications?
Yes,
Mr Dharmananda.
thank you. Mr Bossy, it's been a long day. I hope not to be too long with you. You mentioned in your witness statement about a change in the business strategy of Crown Perth at paragraphs 52 and 53. And you speak about the 4 pillars of change in respect to that strategy. Could you explain how that strategy came about and what led to its development?
2016 was a tough year economically. All the statistics were poor. There was very clear direction that we were asked to reduce costs, which meant staff members' jobs. I think it was early 17. I was asked by a senior member of our executive team whether we needed my job, which is a shock, but my response was that's a matter for senior member to decide rather than myself. So the world changed at that point from the organisational perspective. What we decided, where we were going to change our direction was we wanted better strategic alignment. We were, as a business, to save as many jobs as we could and reposition the business. We had to succeed as a team. Two key areas we focused on was strategic alignment and leadership development. Leadership development became a core priority for us. We established an executive subcommittee, which was information we garnered from CEO women of what one of the banks was doing, and we put together our leadership team, 2/3 female, 1/3 male, to develop leaders of the future and let them take on some of the decision-making responsibility that the executive team would have, so they'd understand what that meant. It helped us break down business silos, so now businesses and the team would work together, understand each other's business, so as to maximise the overall benefit for all. Collective responsibility became our mantra. From that, and we had 3 runs of that using our business operations team to develop all those leaders. So that became a real core for us. The other core was we developed a project framework where we again chose leaders. We extended to the business operations teams we discussed earlier. Non-subject matter experts would lead those projects because they needed to be open in questions, open up communication across the business, and get initiatives growing across the business again. We then aligned our business into initially 4 within 5 key pillar themes, and every business unit created their independent strategies in line with those leaning up to where the corporate strategies were. It enabled us to simplify the business, it enabled us to simplify communication, and enabled us to start to develop a tied up, more consolidated plan. With that, we also started working on cultural development within the team. We introduced a training program that was Mary Gober International coming out of Qantas to get a better service model in play. We introduced mindset training. We were undergoing a stressful time for staff, and resilience training to get the team in the right mindset to address what was going forward and coming towards us. Recently, we've introduced psychological safety workshops with our leadership team. So it was all about let's get them in the right mindset to deal with the changes and the challenges we had, have the leadership team lined up accordingly in terms of leading those teams and communicating better. Communication's a key for our business. We have 5,500 staff, and about half of them are born overseas, and a vast majority don't have English as a first language. So communication becomes a key when you're building a service model to a customer that has very different views on service expectation and quality. They are inconsistent, our customers. You've got 10 million individuals touching or communicating, interacting with 10 of our staff. That's 100 million interactions a year. I've got 5,500 staff, about 30% of which don't have English as a first language, and we're asked to deliver a service that is seamless and 5-star in essence. So there was a lot of work done over the last 3 to 4 years to reposition the entire organisation. Our marketing campaign shifted to a value proposition, broad-based scale, so we didn't focus on those high-end customers, we focused on the masses. So business strategy was completely divergent to probably where most casino thinking is, and I think it's a piece of work that has transformed the organisation and how we work together. That was and that's taken us 3 to 4 years to get there. Culture shift doesn't happen easily, but you need leadership, you need a clear plan, you need that cultural support to get to the outcome. I think the team's very well aligned at the moment. So a significant shift in where the business has gone.
And was that an initiative taken in Crown Perth, independently of Crown Resorts Limited or Crown Melbourne?
Yeah, absolutely. This is not a framework that exists in Melbourne at all. It's about how we run the business. It's how we develop our people. It is a team that works together, that is happy to speak up in all environments, and I'm proud of where they're at.
Mr. Bossy, you were asked some questions in relation to your interactions with Ms. Fuster. What feedback has Ms. Fuster given to you as an independent director in relation to your performance?
The feedback I've got from Ms. Fuster has been positive. The communication and dialogue we have, particularly over the last couple of months, has been open and easy to have and clear in terms of what we're discussing. She has advised me that I'm doing a good job in the circumstances that are quite a challenge for us.
Thank you. You were asked by Council Assisting in relation to what Crown does in terms of giving work locally to Western Australian businesses, and you gave a response. You're aware that there was also more formal material provided to the GWC or the department?
Yes.
If I can ask you please to go to crw.513.017.2951. See there that this is a letter written to Mr. Connolly, and it's written by Mr. Felsted. But at page 2953, at about the second arrow, you'll see there's a reference to benefits to the broader Western Australian economy, and the bullet below that indicates the amount of goods and services procured from the Western Australian businesses. Do you see that?
Yes.
And I think the figure that you mentioned in answer to questioning this morning was 800.
Yeah.
Is it between 800 and 1,000 businesses that Crown
I understand
contracts
that that's where it is today.
And then in the next arrow, you'll see a reference to the amount of the procurement that takes place within the state of Western Australia. And do those figures there, once you look at them, accord with your understanding?
Yes, they do. Certainly in food and beverage supplies, it's consistently been in the 80% range over a number of years.
And the procurement otherwise at 66%, which is about 2/3?
Yes, there's certain items that we can't source in Western Australia, but certainly that's the scale of it.
Thank you, Mr. Bossy. Thank you, Commissioners.
Thank you, Mr. Darman. And are there council not physically present in the room who wish to ask Mr. Bossy any questions? I'll take that as a sign.
No, thank you.
Thank you. Commissioner Jenkins.
I'll try and be quick too, Mr. Bossy. Can I just ask you in relation to AML training, did you receive any AML training either before or when you became COO of the casino?
When I first arrived in COO, no, AML, back in 2000 COO, back in 2013, AML was not anywhere near as progressed as it is today. A lot more training recently, and far more familiar with it. Part of it's got to do with Mr. Blackburn coming on board. He's an expert in his field. I've had online training. I've had what we call targeted training. So our key teams that deal with the customers in those areas, whether that's gaming team, security, cage, have specific targeted training from one of Mr. Blackburn's team, and then also as a board member we had further training around AML at that point. So I feel far more comfortable not only in the training but in also the fact that we've increased our resourcing significantly, both in terms of skills are outstanding, I think, but also in the number of people, and we're still recruiting. So his fin crime and compliance team is significant now.
So when did you first receive what I will describe as formal training? So either online training or actually instruction in AML, CTF programs and the implementation of them?
I can't recall, but it wasn't that many years ago.
2017
maybe.
And what would have been your first training?
First training in terms of
AML.
That probably would have been it.
Sorry.
At that time, the online training would have been online, and I actually, from my perspective, through discussions with the legal team who had some AML responsibility, I actually probably got more out of the conversations. To be fair, I've found even when I first arrived at Crown, you can have traditional induction, but actually talking to team members probably gives you a lot more information and depth and allows you to ask questions one-on-one. So I found that was more effective than the training.
In respect of the Riverbank account, did it occur to you that the GWC should have been told that this was a bank account which the Perth Casino was using?
I wasn't aware whether they weren't or were aware. I think it's certainly something they could have been told, yes.
But as COO, when you became the signatory of the account, it didn't occur to you that we better tell the GWC about this operation account?
The bank accounts were traditionally run out of our cage and finance team, which went through to the CFO, and so I to a degree relied on the expertise of that team and the processes. They're still in line with the same process we are in terms of GWC and compliance.
So when you're talking about the CFO there, is that the CFO of the Burswood entities or of Crown Resorts entities, or what level? Are we
in
about?
14, it would have, I think it was the Perth entities at that time. In fact, it was the Perth entities at that time. And the CFO was on the executive team, had as much engagement as I had with the legal team, and would have had the compliance, would have understood the compliance requirements. So I didn't proactively go there knowing that, or in hindsight, I should have given what's occurred, but at the time I was relying on the CFO to ask those questions.
And the general manager of the cage reported to whom?
At the time, at the moment it's CFO, but at that time, I can't recall. I think it was the CFO, but it could have been the our EGM of legal at the time.
And do I understand, in answer to questions asked by Ms. Cahill, that no manager or employee in the cage at Perth Casino ever raised with you that they had suspicions of money laundering occurring at the Perth Casino?
The cage would have gone through their CFO or CLO as normal chain of command. So I don't recall.
What they would have done.
No, I don't recall.
Never.
I don't recall them raising that.
in the letter that was written to, I think this was a letter you signed, to the GWC in respect of the change to the WA appendix to the EGM standards. There is a reference there to the, quote, clear distinction between EGM and poker machines. What's your understanding of the clear distinction?
Can we bring the letter up? Or that's fine. I think that was written by Mr. Falstead, the letter, with the EGM submission. The
And
distinction,
just generally, what's
distinction
your
for me
understanding?
is the distinction is the what we call the delivery mechanism and how it spins in the plane of the screen itself.
Sorry, say that again.
The-
What was the first thing?
It's a delivery mechanism. So when you look at the game, they look very, very different to what a spinning reel does. Spinning reel spins fast. Appearance is materially different. You don't have truncation of credits. The pattern of symbols, I believe, are different as well in terms of the way the game, a lot of the games have worked. But certainly the appearance of the game is the most distinctive feature.
Now, as I understand your evidence, the ICB business was at Perth Casino was primarily organised, managed and controlled outside of your chain of command, so to speak.
Yes.
And so, in respect of our terms of reference, where we're directed to the findings of the Bergen inquiry in respect to the facilitation of money laundering through the Riverbank and South Bank accounts, you say you knew nothing about that.
Until I saw the reports from...
Yep. And then in respect of ICB business, you would say you had nothing to do with the China-based staff and what they were doing?
I had no visibility of the China-based staff.
Because they were organising ICB business if they were doing anything, would that be right?
Yes.
And then in terms of entering into and continuing commercial relationships with junket operators who had links to triads and other organised crime groups, you would say that that also was part of ICB business that you had nothing to do with?
Those arrangements would have been signed centrally.
So what I want your opinion on, Mr. Bossy, is this. Is it in your view desirable that you as COO of the Perth Casino had no control over that part of the business which was going, which related to, nonetheless, Perth Casino?
It wasn't desirable. The way internally it was structured and managed is what I'm describing, but the process was a challenge.
And why was that?
Because it was managing from an operational perspective, the communication flow needed to be probably better for us to actually operationalise some of those visits. It worked, but it was patchy for us. We'd have if we had a tournament or we had a large group of customers that came in, oftentimes it would be something like, say, a Chinese New Year, trying to manage those customers coming in. They used to be of reasonable volumes. We didn't necessarily have a facility that was built to cater to that supply. So it became a challenge for us, and the information flow would often be late, not early. So I'm just, if it was totally in the control of the environment, planning would have started a lot earlier and what have you. So it was a bit disruptive operationally.
And you described current changes or in process to break down silos, business silos, as you've described it. Would you describe the ICB business when it was operating as a business silo that you did not have sufficient knowledge of?
Yes.
Thank you. I have no further questions.
Mr. Bossy, I've only got two questions for you. Could you bring up the witness statement, paragraph 20, please? So I appreciate that you say there you're an interim, you're a director on an interim basis. I appreciate that.
Yeah.
I'm interested in the last sentence of that paragraph. And this is something we'll come to with other people later on.
Yes. So
I'm only asking you about your knowledge and discussions in which you might have been involved. Have you been involved in any discussions about the type of board for Burswood Limited that would be most appropriate for the circumstances of Crown Perth?
A couple of ways I can answer this. Firstly, Ms. Fister and I in particular have had a number of conversations on what that board should look like in terms of composition, skills, and domicility. The skill set that we've discussed has been obviously we need some legal and risk capability, finance capability, business acumen. You want some integrated resort experience. The independent board members that get applied would like some more West Australian representation. The discussions I've had at a resorts level with Ms. Coonan was presented some names of potential people. I can't recall them at the moment, but potential, it was a few months ago, potential people who could sit on a resorts board as well that were from Western Australia to try and get better representation.
That's the Crown Resorts Limited.
Yes, yes. So, and I would that may well become in a world where you've got a two-board structure like we have with Perth and Crown Resorts, that person could sit on both of those boards as well. So there has been some dialogue about that. Not a lot, I've got to agree, but I think part of the challenge on the interim process is it's a small board. I'd like to have a few more on the board in Perth.
Even on an interim, even in this interim period.
Yeah, well, the interim period is more about my position on the board. I feel as though, well, not feel as though, when I think about the boards that I am on, I've been placed on those boards due to departure of people. The resort management board was I was put on there because Mr. Felsted resigned on the 31st of December, and I was on the 1st of Jan, so I got a rushed position in that space. There was discussion about we needed someone on. When you look at some of the other boards, a lot of them were the 15th of February, which coincided with Mr. Barton leaving on the 14th of February. So the interim position is I think the concept of interim is let's decide on what is the right framework of the board, and then from there we can determine whether it's interim or permanent.
So you've had discussions with Ms. Fuster about those issues?
Yes.
And is it fair to summarise what you said by saying that you passed at least the tenor of those discussions on to Ms. Coonan?
I've had some discussions, and I've similar, probably more detailed, to be honest, with Ms. Fuster, because we do communicate fairly regularly. But I have forwarded names and had some cursory discussions more so with
All right,
Ms.
thank you. Now, my other question is, now, I hope I hope what I'm about to say is an accurate reflection, a reasonably accurate reflection of what you said in answer to some questions from Ms. Cale. So please correct me if I'm wrong, but you remember at one stage Ms. Cale asked you questions about how you saw, this is in your period as COO, how you saw your accountability as to the boards of the various companies. And I think you said you felt more accountable to the CRL board than you did to the Burswood Limited board.
As COO,
As COO.
As COO, I had more visibility of the Burswood Limited board. I was attending those meetings. I knew the participants of those meetings. Whereas a lot of the resorts board I'd never met before. But as part of our business process and our business planning process, we did go through a scenario where we made presentations to members of the CRL board. So there were certain members in that area that I felt some obligation to because of the business planning process and the financial side of the business, but most of those were common members. Mr. Alexander was on both the Burswood board and the resorts board. Mr. Johnson at the time was also in those meetings. He was on both boards. And also I present to Mr. Felstead and Mr. Barton. So there was some...
So do I take it from that when you use the word accountable, you weren't using that in the strict sense, but rather an obligation to correspond with, to discuss with people with whom you are not as familiar?
Yes.
Okay. And then as part of that same exchange, you said that, and the note I took was that over time, in relation to strategic planning, the nature of your interactions changed and you became, there were better discussions with the Burswood Limited board. Do you recall saying that?
Over time? Can you
Over
repeat?
time,
Yes.
in relation to strategic planning, the nature of the interactions changed and you had better discussions, that's the note I took, with the Burswood Limited board. And I'm just wondering if that's an accurate reflection of what you said, what you meant by the change over time.
The interaction I had with the two boards was very limited, certainly in that COO role. Certainly CRL board, there was only certain members that I interacted with. As time passed, I formed a better relationship with the members of the Burswood board. And so the communications we'd have, certainly whether it was CEO reports or what we were doing, I felt like I was contributing more to the discussion of where we were going, whereas I'd never presented to a CRL board at all until earlier this year.
All right, thank you. Thank you very much, Mr. Bossy. Anything, Ms. Cale? Mr. Bossy, I know it's late and this is a very tiring process, but as you sit there now, is there anything else you would like to say to us? It's an invitation to you. I'm not suggesting there is anything.
Look, thank you for your time. It's been a tough time for all of us, and really for me, it's the team on the ground that's the one that's bearing a lot of burden as well that a lot of people don't see. They work hard. They 5,500 staff who live in many instances paycheck to paycheck. They love what they do. They love their family. They go and eat barbecues with friends, and it's about them as well. The decisions we take, and they mean a hell of a lot to me as their leader. They are what we're about. We're a human business that lives by our values to deliver an experience to our not only our customers, but also our employees. A lot of back of house people that work together to provide support, and the frameworks that we put in place. Yeah. One of the things about the way we work here, one of the challenges we have is the framework that we're asked to operate under. We're talking about our relationship with the Gaming Commission and the department. But for us to operate, we deal with WAPOL and about 6 different arms of WAPOL, to be honest. We deal with AFP, we deal with Austrac, we deal with Department of Health, we deal with the town of Vic Park. The framework that exists that we hold together across the state, the multiple departments, there's something like about, if I recall correctly, I'll probably get it wrong, but 50 or 60 different authorities we are required to deal with to get not only be compliant, but provide the service and the offering that we provide to the community and to our staff. And that's the framework I think that also needs to get into context. How do we get to the right framework? We somehow are the linchpin to a lot of that, and I don't know if that's the right way the framework gets set up. I think it's a real challenge for us to look at. And our teams work independently with each of those groups to try and get to an outcome, to deliver a result. And I'll give you an example, just something as simple as what we decided with the Pearl Room to go to non-smoking. I ended up meeting with WorkSafe, Department of Health, Department, the Gaming and Wagering Commission, and the ministerial approval we're going to have to get. That's just to do something that is positive for the customer. And it's a tough time for us.
All right. Well, Mr. Bossy, thank you very much. Your evidence has been of assistance to us. There may be some tidying up to do, so we will leave the summons in place, but you're free to go and with our thanks.
Commissioners, just in light of the fact that Mr. Bossy hasn't been released, we may need to speak with him on other things. I assume
that's appropriate.
Thank you.
That's appropriate. Yeah. All right. We will adjourn and resume at 10 a.m. tomorrow.
All rise.